So we have a viewer question. What if an IRA was supposed to be funded into a trust, but the lawyer didn't do so, even though he told my bedridden mother he had? So two important questions, right? Should the IRA be included in the trust? Can depend on individual circumstances. And does your attorney actually handle trust funding as part of their estate planning services? At our firm, we typically only fund in the real estate and business interests into a trust directly. But for assets like an IRA or some kind of retirement account, that usually includes a change to the beneficiaries, not necessarily the transferring of the title. As a little background. Valerie Zammitti of Zammitti Law. We're an estate planning practice in New York and New Jersey. We provide peace of mind to families through our high client value services. If you are in need of assistance in preparing your estate plan, or you need assistance with the administration following the passing of a loved one, you can reach out to us for a free consultation at yourplanningattorney.com. Proof that brain blips happen. Anyway, we are always here educating as best as we can, so please ask questions and, of course, share so we can help some folks along the way. First off, you do need to check the scope of the retainer with the attorney and determine whether or not funding is actually included. Funding can be the retitling of assets or can be the changes to the beneficiary designations. As I mentioned, is the most common with retirement accounts. But if it's not included in the scope, I would say that the attorney wasn't responsible and didn't intend to do so. Perhaps there was a miscommunication. Now, again, the reason we only handle real estate and business transactions is that's something that we can easily accomplish for the client, is usually harder for the client. When it comes to bank accounts, financial brokerage accounts, retirement accounts, life insurance policies, those changes, whether it's a retitling or a beneficiary change, is usually easier for the client to do on their own, of course, with our guidance, some specific tools that we give them, and then we follow up for a period of 6 months or more to make sure it's all getting done smoothly. Otherwise, while we can get involved, it takes more for an outside party to do those steps. Now, if funding was actually included in the retainer agreement, then you need to consider what damage there had been created by not doing so. So, for instance, if mom's estate plan says everything goes outright to the children, and the children were still named as the beneficiaries under the retirement account, what difference is there? So, if there's no financial ramification or impact on the beneficiaries, then really there's not much of a change. And the costs of doing something about it is moot, it's pointless. Now, if perhaps there's no beneficiary on the retirement account, and it then necessitated having to go through a probate just for that retirement account, I would say, okay, maybe there's some additional cost going through the probate process. But then again, the fees and costs to do so are not necessarily an amount worth litigating over. Or perhaps there's additional benefits that were lost to the family based on the failure to fund the retirement account in the way that was expected. Now, I'm not even certain in the circumstance whether mom is still with us or not, but if she is, obviously the change can still happen, and that can be accomplished. And I would say, the family members can assist mom in getting that done. Certainly if the law firm is not, even if they promise to do so. If she has passed, sometimes a court will allow what's called a post-death reformation to her plan to try to put things in line to what mom's intent was. But that would require a petition into the court and a subsequent order from them to be able to make those adjustments. Now, of course, whether or not you choose to take any action against the attorney, if they really did fail and there was a loss to you, I typically believe there's a better way to reach the ultimate result you're seeking without going through the litigation process. But that is a personal opinion. Just because I'm not a litigator, I think it ends up creating more harm than good. And, that's coming from an attorney with a little bit of experience. Again, I'm Valerie Zammitti of Zammitti Law, an estate planning attorney in New York and New Jersey. Again, we provide peace of mind to families through our high client value services. If you need us, you can reach us for a free consult at yourplanningattorney.com. We hope you've learned something new here today. Don't forget to share. And as always, take care. Bye-bye.